One oddity, I think, that you have to deal with is that your theory would mean that claims against brokers would be preempted for intrastate transportation, but not for interstate transportation, which seems a bit backwards in terms of preemption. And that's something, if you think the question here is how broadly to read with respect to motor vehicles, and you're thinking about context and common sense, which you mentioned, that seems to be in tension with that. You want to respond to that?
I would love to, because I think there is a counterintuitiveness to the fact that Congress seems to have provided a broader preemption provision for interstate routes, prices, and services for brokers and freight forwarders, and a smaller preemptive scope for interstate. Now, that anomaly is going to exist no matter how you decide this case, because B is broader not just because it doesn't have a safety exception, but also because it doesn't have the phrase with respect to the transportation of property. So, so like a case like Dan City, where this court said that with respect to the transportation of property is what meant there was no preemption, there would be preemption for interstate. Now, I'm not here to tell you that makes any sense. But what I am here to tell you is that Congress in 1995 made a very deliberate decision to treat brokers and freight forwarders differently for interstate and for intrastate. I mean, it would have been the easiest thing in the world in 1995, because remember, brokers are added to both a year after the principal statute. It would have been the easiest thing in the world to create like a subsection that was about brokers and freight forwarders for interstate and intrastate. But Congress didn't do that. They consciously had a separate sub-B clause for intrastate, and then they consciously dropped the brokers and the freight forwarders into C, which already had the safety exception.
Just going back to the real world, though, a broker in Los Angeles who arranges a trip to San Francisco, no tort suits available. But if it's to Reno, a tort suit is available under your theory, right?
Under our theory of the safety exception. Now, you might
on the safety exception, right, which is the key. And I guess I'm still trying to figure out how that makes some sense, particularly when, let's just add to it, the other kind of issue that bothers me a little bit here is the fact that Congress required financial security requirements for the truckers, but not for the brokers, and with respect to accidents. And that seems another thing that you can respond to.
Sure, but let me respond to them in turn. So starting just to reiterate what I said with B, I mean, look, I'm not here to tell you that that's not a little bit anomalous, but it would be more anomalous to take two statutes, one of which has a safety exception and one of which doesn't, and interpret them to mean the same thing. And there's no question that B is not the applicable provision here. C is the applicable provision. And as I said, no matter what you do with the safety exception, you're going to still have an intrastate provision that has broader preemptive force than the interstate provision, because B doesn't have that with respect to transportation.
What about the financial security requirement? If we're trying to figure out what Congress was doing, which I think you've talked about here in 94 and 95, they say that the trucking companies have to have financial security so they can pay judgments with respect to accidents, but they don't do that on brokers. And when you combine the two things we're talking about, that's in tension with your position, but what's your best response to that?
Well, I think I have several pretty good responses to that. I mean, one of which is it's even more complicated than that, because freight forwarders were also supposed to have some insurance against injury risk. So you can't make some idea that everybody in the sub B is different from everybody in the sub C, if you're following me on that. But more to the point,
I am, but if Congress envisioned tort suits against brokers, why not require brokers to have the insurance to pay the judgments?
Because I think Congress rationally said we want to make sure that they have a financial security requirement that is responsive to the principal financial risk that they face. And it's different with respect to carriers than with respect to brokers. The principal financial security risk that brokers have is default. But you can't read too much into the insurance requirements, because nobody thinks that carriers can't default. In fact, carriers are defaulting all the time and going bankrupt all the time. And so you can't draw too strong an inference. And what I would also say is there's also sort of an asymmetry in the inference that you would draw. Because, some lower courts, for example, have focused on that insurance requirement by finding that safety torts are not preempted in the Airline Deregulatory Act context. But that sort of makes sense because it would be very weird for Congress to force a carrier to insure against a risk that is actually zero because the risk is preempted. So when Congress says you must insure against something, it's actually a pretty positive sign that there's not preemption. But I don't think it works the other way around. There's all sorts of contexts where you say things are not preempted and Congress hasn't even thought to make somebody insure against it. So I just don't think, I don't think there is a presumption against preemption in the express preemption context, but boy, you need something more than an insurance requirement to ignore the plain text of a clause that is designed to deal with the issue of preemption straight up.
Can I take you back, Mr. Clement, to Justice Kavanaugh's first set of questions, the interstate, intrastate, and you said you're not here to tell us that it makes any sense.